Hello everyone, welcome back to the channel Ajay Sharma Law. So today I am going to discuss a very landmark case law, Sakiri Vasu versus State of UP 2008. Have you ever wondered that happens when you go to the police to report a crime but they just don't listen? What are your options? Today we are diving into a landmark legal case that gives you the power to hold the police accountable. Sakiri Vasu versus State of Uttar Pradesh. So let's start. Sakiri Vasu versus State of UP 2008. Imagine a situation. A serious crime has been committed. You have all the evidences. You go to the police station to file an FIR, but the officers refuses to register it. Or maybe they registered it, but they do not investigate properly. What do? Most people think their only option is to file a complaint with a senior officer. But the law provides a much more powerful solution. In this case of Sakiri Vasu versus State of UP, this is exactly what happened to the Sakiri Vasu. His son, Major S. Ravi Shankar, died under mysterious circumstances. The police and army called it a suicide, but Vasu believed his son was murdered. He wasn't satisfied with their investigation and wanted a proper one, even a CBI inquiry. So that's the fact of the Sakiri Vasu versus State of UP. The case arose from the death of Major S. Ravi Shankar, whose body was found on the railway track in Mathura, UP. The police and the army concluded that his death was a suicide or accident. However, the deceased father, Sakiri Vasu, alleged that his son was murdered due to his knowledge of a corruption within the army unit. Dissatisfied with the investigation, he sought a CBI investigation. When the High Court dismissed his writ petition, he appealed to the Supreme Court. So basically, these are the facts of Sakiri Vasu versus State of UP. Now, here's where the magic happens. While the Supreme Court ultimately didn't order a CBI probe, it used this opportunity to lay down a crystal clear roadmap for every citizen. The court said, you do not need to run to the High Court away. You have a legal step-by-step process you must follow first. This process is your superpower. So step 1. The first thing you do is approach to the Superintendent of Police with a written complaint. The law, Section 154, Clause 3 of the CrPC, I'm not talking about the BNSS, I'm talking about the CrPC, gives you this right. Now you answered in comment which section deals with the same procedure as under the BNSS. Step 2. If the Superintendent of Police doesn't take action, you move to the most powerful step. You file an application with the Judicial Magistrate under Section 156, Clause 3 of CrPC and comment your answer which section deals in BNSS. The Supreme Court in the Sakiri Vasu case said that the magistrate powers is incredibly wide and robust. The magistrate can order the police to register the FIR if they do not have. If they haven't, direct the police to conduct a proper investigation if the existing one is sloppy. Monitor the investigation to make sure the police are doing their job and then recommend a change of the investigating officer. This ruling essentially made the magistrate first line of judicial defense against the police inaction. It puts the power in the hands of the common person and ensuring a speedy remedy. So the next time you face a situation where the police are not doing their duties, remember of Sakiri Vasu versus State of UP, do not feel helpless. Use your rights under the law. First contact the Superintendent of Police, and if that doesn't work, go straight to the magistrate. It's your legal right to a fair investigation. So that's all about the Sakiri Vasu versus State of UP. The Supreme Court, while dismissing the appeal and upholding the High Court's refusal to the order a CBI probe, used the opportunity to lay down a clear procedural framework for citizens seeking a proper police investigation. The judgment of Sakiri Vasu versus State of UP established the following principles. Exhaustion of statutory remedies. The court held that a person aggrieved by the police inaction, such the non-registration of an FIR or an improper investigation, should first exhaust the remedy provided under the CrPC before approaching the High Court with a writ petition. Step by step should be followed, not directly to the High Court. Hierarchical remedies. The proper course of action for an aggrieved person is the first approach to the Superintendent of Police with a written application under the Section 154, Clause 3 of CrPC. If that fails to yield satisfactory results, the aggrieved person can file an application under the Section 156, Clause 3 of CrPC before the concerning magistrate. तो बेसिकली सी बात ये है कि आपको जो है डायरेक्टली, अगर आपकी जो कंप्लेन है वो पुलिस नहीं लिख रही है, तो आपको डायरेक्टली जो है हाई कोर्ट में रिट पिटिशन फाइल करने की ज़रूरत नहीं है। आप पहले स्टेप बाय स्टेप फॉलो करके जो है वो अप्रोच कर सकते हैं। जैसे कि सकीरी वासु वर्सेस स्टेट ऑफ यूपी में बताया गया है कि आप फर्स्टली सुप्रिटेंडेंट ऑफ पुलिस को जो है इन्फॉर्म कीजिए। अगर फिर भी कोई एक्शन नहीं होता तो फिर आप मजिस्ट्रेट के पास जा सकते हैं। तो ये जो है ये एक हायरार्कियल जो है स्टेजेस बाय स्टेजेस चलेगा। ऐसा नहीं है कि आप डायरेक्टली जो है हाई कोर्ट के अंदर रिट पिटिशन जो है फाइल कर रहे हैं। सबसे जो प्रोसीजर हमारा CrPC में दिया गया है वो फॉलो होना चाहिए। तो बेसिकली सी बात ये यही इस केस में बोला गया था। Board's powers of the magistrate under Section 156 Clause 3, the Supreme Court emphasized the extensive and wide-ranging powers of a magistrate under the Section 156 Clause 3 of the CrPC. The judgment affirmed that a magistrate has the authority to order the police to the register an FIR if one has not been registered, direct the police to be conduct a proper and thorough the investigation even if an FIR already been registered but the investigation is deemed unsatisfactory. Monitor the investigation's progress to ensure that the police are performing their duty diligently. Recommended a changes of investigating officer to concern superintendent of a police if necessary. No right to a specific investigative agency. The court retired that an aggrieved person does not have the right to insist on an investigation by a specific agency such as the CBI. An investigation by the CBI should only be ordered in the rare and exceptional cases. So that's all about the Sakiri Vasu versus State of U.P. पूरा प्रोसीजर जो है वो फॉलो होना चाहिए। थैंक्स फॉर वॉचिंग गाइज। इफ यू फाउंड दिस वीडियो हेल्पफुल सो डोंट फॉरगेट टू लाइक, शेयर एंड सब्सक्राइब। ओके, बाय बाय गाइज, सी इन द नेक्स्ट वीडियो एंड डोंट फॉरगेट टू comment that answers. Okay, bye bye guys, see you in the next video.